Okay. Welcome again, everybody. Jeff Jenkins and Eric Klayman here for our weekly Facebook Live presentation. And we're going to talk today about some of the problems COVID's created and how bankruptcy can solve them. Things that you could do in a bankruptcy to take care of issues that may have arisen because of COVID. And I have to say, we're also getting ready for the Army-Navy game, which doesn't mean anything to a lot of people, but to some people it does. So I've got my West Point top on today because I went to West Point. All right. We're going to talk about mortgages and landlord-tenant things first. So as this COVID thing has progressed, there have been special arrangements made for mortgage companies and people who have mortgage loans for tenants. And we want to talk about that. What is going to happen when the mortgage company or the landlord says, okay, they said that you were protected until the 25th of January or whatever the date is, and it's the 25th. So what do you want to do? So why don't we start off with mortgages?
Right, Jeff. Hi, everybody. What we're going to be talking about, as Jeff explained, is the government shutdown as a result of COVID-19 and the fact that as a result, people didn't go to work and didn't get paid. For a while, there was extra unemployment. The federal government chipped in the extra $600 a week, so defaults weren't that bad, but that ended. And now as we've gone through August, September, October, November, now December, due to some dysfunction in the government, because both parties wanted there to be more money given to people, but no more money was given to people. So there's a lot of defaults. You can do a simple Google search and see defaults on mortgages, defaults on rent. The numbers are astounding. So what do you do if you know someone who's behind with their mortgage, or if you yourself are behind with the mortgage? What can you do to help yourself? And even before COVID, there was an answer, which was filing a petition into bankruptcy, really. A bankruptcy petition offers many, many options. And there's two concepts that we want to go over and make sure you understand them. Number one, the moment a bankruptcy petition is filed, the person who files bankruptcy is protected by what's called the automatic stay, which stays or stops all collection actions. Now, Jeff introduced this, but we're going to talk about mortgages. So what does that mean? It means that even if the mortgage company claims you're in default, has hired a lawyer, and has sued you and has scheduled a sheriff's sale, you can still file a bankruptcy and it calms things down. There's the automatic stay provisions of the bankruptcy code, which stays or stops the action. The second concept generally is discharge, and discharge means at the end of the bankruptcy, you won't owe the credit cards and the medical bills and what we call unsecured creditors any money. And why that's important, Jeff, even when you're talking about saving a house, is we work on budgets with clients all the time. And if we tell the client, hey, we can get rid of your credit card debt, we can get rid of your medical bills, do you have enough money to resume mortgage payments? Often the answer is yes. Mm-hmm. So those are the two concepts, the automatic stay and discharge. And then we can talk about two different types of bankruptcies which consumers can do to help. Right, Jeff?
Yes. Let me talk about that.
You may.
Okay. If you're going to do a Chapter 13 bankruptcy, and that's the kind that we're talking about for a consumer, and you've got mortgage arrears, you can do one of two things. Number one, you can pay the mortgage arrears through the Chapter 13 trustee. So every month, starting the month after we file the bankruptcy, you've got to make your normal monthly mortgage payment that month and every month after that.
And Jeff, just to be clear, the mortgage company will accept it. You could be 7 months behind or 17 months behind.
Yeah.
Once we file bankruptcy, right now they send you a demand letter, $23,000. They want the $23,000. That's not what happens once we file bankruptcy, right?
Right. Yeah, they must accept the monthly payments that you start to make. And if there's any problem, and there's a problem with that every once in a great while, we'll usually send the payment, get a payment from you and send it to the attorneys, tell them you got to tell your client to accept the payments, and that kind of takes care of things. You're paying back your mortgage arrears, but as Eric alluded, depending on your income and other things, it's possible in most cases for us to get rid of all of your unsecured debt, credit cards, medical bills, loans, things like that. So the bankruptcy isn't just dealing with a mortgage. That's our focus when you're behind with your mortgage. But there's other things the bankruptcy is going to do for you. Now, with COVID and some of the things that have passed Congress and some of the directives from the federal government, federally insured mortgage loans, actually, I guess it's just Fannie Mae and Freddie Mac loans now.
They just changed that.
Yeah.
Yes.
And it was Fannie Mae and Freddie Mac loans that you couldn't go forward with a foreclosure. And that's been that way for a couple of months.
And has continued.
And they had December 31st as the end date or the beginning date when they could resume foreclosure activity. And they just extended that to the end of January for Fannie Mae and Freddie Mac loans. That doesn't cover FHA, VA, USDA. What am I forgetting?
Regular loans too.
Well, it certainly doesn't cover regular loans. And the government-backed loans constitute about 70% of the mortgage loans that are out there. So the other 30% have always been, since the COVID business started, they've always been able to do a foreclosure, but they've been kind of reluctant to, we understand from our colleagues who represent the mortgage companies. What else?
Well, you said there were two options.
That's right.
So if you're behind with your mortgage, Jeff just described a mortgage arrears plan, which is probably the most, I would say that's what we file the most.
Yeah. And the other plan would be to try to get a loan modification from your mortgage company. We do that if the arrears are so significant that there's no way you could pay them off in 5 years through the Chapter 13 trustee. And that might work and it might not. Mortgage companies are generally pretty good about doing that. Even when you're in a bankruptcy, surprisingly, I think they don't want to fool with a bankruptcy. And we've had clients that have been turned down for these loan modifications, and then they filed a bankruptcy and they got one. So that's not a bad way to go. The mortgage companies could also make an arrangement with you themselves. And we've seen things about that from the federal government giving direction to the federally insured mortgage holders. They can look at you and think about loss mitigation. Do you qualify for a loan modification? What about anything else? And the federal government has also told them that if they want, they can take whatever arrears exist and put them on the end of the loan rather than go through the time it would take them to deal with the really significant number of mortgage delinquencies that exist. It would be much easier for the mortgage company just to do that rather than entertain loss mitigation arrangements from all of these people. The situation with the mortgage company I still have questions in my mind anyway. Clearly, if you've missed mortgage payments because of COVID, that's one thing. What if you went into COVID owing 3 months worth of mortgages or payments or 6 months or something like that? Is the mortgage company able to put those on the end of the loan? Well, they can do whatever they want, but I'm not so sure that those things are covered by all the stuff that we just talked about and the directions from the federal government. Certainly, the mortgage company can't go forward with a foreclosure if it's Fannie Mae, Freddie Mac until the end of January, and that would include if some of the delinquency consists of pre-COVID mortgage arrears.
But Jeff, what we're saying and what we've talked about is even though these programs are available, sometimes the client is just so happy to hear that we have a way for them to catch up on the mortgage that is also legal, and not only legal, it's part of the law. So we can tell them, okay, you can wait for this, wait for that, but you're back to work now and you can afford your mortgage. So rather than mess around with all these Is it a federally insured loan? Is it Fannie Mae? Is it Freddie? We don't care. File the bankruptcy in December. Beginning in January, the mortgage company will accept the payments. And then we do an arrears cure. In other words, the arrears are divided up over 5 years or less. And you make the payment to the trustee who takes the money and pays the mortgage company back. For the Chapter 13 to work, you really only have to do two things: pay your mortgage each month and pay your trustee each month.
Right.
But Jeff, there's another type of bankruptcy that we're seeing some of our clients use. The most popular bankruptcy in the United States, the Chapter 7, wasn't necessarily designed with mortgage arrears in mind. The Chapter 7 bankruptcy was designed, typically someone's current with their mortgage, but they have a lot of credit cards or medical bills or attorney's fees relating to divorce. We see that a lot.
Mhm.
So you file a Chapter 7 to get a fresh start. But if the people come in and see us and their neighbor next door has two big, loud dogs and they could never imagine living next to them again, and they're behind with their mortgage, and their kids have already left school and they want to size anyway, and they can't sell their house because they owe more than the house is worth, Chapter 7 can help there as well.
Exactly. Yeah. With either a Chapter 7 or a Chapter 13, when you've completed the bankruptcy, you're going to get a discharge of your debts. And one of the things the discharge operates on is the mortgage note that you signed when you got your mortgage loan. You sign a lot of pieces of paper for the mortgage company when you go to a settlement.
Yes.
In fact, I used to work for a law firm, and I would think of which pieces of paper needed to be signed. We created them and gave them to the mortgage company. So I was a culprit many years ago in that. But anyway, the two main pieces of paper that you sign are the note, that's like the IOU $100,000 or whatever the number is, and a mortgage. And the mortgage gives the mortgage company a lien on your property. It makes your property their collateral for you repaying the note. At the end of a bankruptcy, it's like the note gets ripped up. The discharge rips up the note, and you no longer owe the mortgage company any money. If you don't make your payments, they can foreclose on the mortgage, but they could never turn around and sue you for any type of deficiency. And that's the good thing if you want to walk away from the house about filing a Chapter 7, because we can make sure that you're not hounded down the road by the mortgage company who sends you a little note one day and says, oh, by the way, you owe us $200,000 because we sold the house finally. And, you know.
And if we have time today, we're going to speak about a similar issue with regards to automobiles as well, because we do have many clients who come to see us who are a bit exuberant and get tied up in these auto leases and auto loans, which looking back on it are ridiculous. And bankruptcy can get you out of them without you having to pay that back. But we'll hold that for a couple of minutes because, Jeff, many of our clients are not homeowners. Many of them are renters, tenants. Mm-hmm. And they call us if they're behind with the rent. And basically, Chapter 7, which we just spoke about, and Chapter 13, the repayment plans, are both available to tenants who are behind as well.
Exactly.
We've seen a lot more of that due to COVID. Again, if you do a Google search, I didn't bring the statistics with me today. I can bring them next week. But the number of tenants behind with their rent in New Jersey is absolutely staggering right now.
Yeah, it's astronomical. I mean, months, we had 29,000 foreclosure landlord-tenant actions, that had been filed and were sitting there in the courts waiting to be processed.
29,000, of course, relates to over 100,000 people because typically in a residence, there's 2, 3, 4, 5 people in a house. So you're talking about 100,000 people who have anxiety about where they're going to live, which is just frightening. And that's why we can help, Jeff. If you're behind with your rent, there are certain COVID protections, but remember, there's plenty of COVID problems which cause these problems. And if you're behind with your rent, we recommend that you give us a call, no cost, no obligation. Call us and see if we can help you. And more importantly, or more on point, if you've already received a summons and complaint, either in foreclosure or landlord-tenant court, you need to speak to an attorney right away.
Yeah, that's very, very important. Eric and I, as we've done these programs, have tried to remind our audience again and again that with mortgages and landlord-tenant things, there comes a point beyond which we can't stop what's going on. We file a bankruptcy after a certain event occurs, there's no automatic stay. The action by the mortgage company or the landlord is not stopped. And for a mortgage, that's the sheriff's sale date. If you don't do something before the sheriff's sale date and you come and
Right.
see us and say, well, my house got sold at sheriff's sale last week, although there are some things we can do for you, but yeah, that's right. It's
We
not
can still help you. Yeah.
we can, but had you seen us before the sheriff's sale,
Much better.
we would have had a lot more options. And for tenants, if you don't see us before landlord-tenant court happens, and I'm not talking about the mediation or arbitration that they've introduced into that whole process, but the day itself when the judge says it gives the landlord what they want or doesn't. If you let that go by and there's a judgment of possession entered, which is what would happen, then we can't stop you from being evicted. In New Jersey, and we've talked about this, evictions are stopped. In fact, the CDC stopped them till the end of the year, like for the last 2 months, because the governor's eviction moratorium stopped on Halloween. So CDC added 2 months to that. And then lately, the governor made January 25th the date after which you could be evicted. So if you don't see us and landlord-tenant court happens, you might not be able to be evicted right now, but when they get around to evicting you, I can't stop it. We can't stop it with a bankruptcy filing. So it's very important, like Eric always says, that if you get something from an attorney, it's filed with a court, and you're a tenant or you have a house and you've got a mortgage, call us up, talk to us about it, come in and see us, bring it with you, or we'll do something on the computer like we do nowadays. You can hold it up and show us what you got, and we can tell you what needs to be done.
So, Jeff, we've talked about the fact that Chapter 7 and Chapter 13 bankruptcies would stop an eviction action, stop a sheriff's sale, stop a foreclosure. The Chapter 13 plan allows for the repayment of back mortgage payments or the repayment of back rent payments, keeping you in the property. The Chapter 7 is a faster process. It gives you a fresh start. As you said, tears up the note so they can never go after you for money. Jeff, there's a lot of financial anxiety right now. And sometimes, this is what I spoke about a couple minutes ago, we're also getting more calls than we usually get about people behind with their car loans.
Mm-hmm.
And if you think about the price of a car, when you leave that dealership and it's more than $500 a month, just remember, in addition to that, you have to increase your car insurance. You're buying gas all the time. It's expensive to have a car in New Jersey right now. New Jersey used to have very expensive gas, but we voted for people who didn't believe in that anymore. So it's just expensive. And Jeff, we can help people who have bad car loans.
Certainly we can. When you come to see us, we're not going to do a bankruptcy just about a car generally. Very seldom would that be the case. If you come in to see us and you've got a lot of things going on, you owe credit card debt, you've got medical bills, whatever, and you have a car loan, we would talk to you about what you want to do with the car loan. And the choices would be these. You can keep it and just continue making the payments, assuming you're current. If you're behind, we could do the same thing that we do with mortgage payments or rent payments, and that's pay the arrears through the trustee, and you would resume making your normal monthly car payments. Right. We can also put the entire car loan into the bankruptcy. So you never have to make a payment directly to the creditor again. All the payments would be made through the trustee. And the final thing would be, if you want to get rid of the car, when we file the bankruptcy, our treatment of the car can be to surrender it to the lender. And you wouldn't owe any deficiency because your discharge, like I said before, would eliminate that deficiency.
Right, that's great, especially with people, and I don't want to get too far in the weeds, but if you've had the car for more than 2.5 years, we can really reduce the payments. And if your interest rate on your car loan is more than 8%, we can really reduce your payments. Mm-hmm. So there's ways we can put the car into the bankruptcy meaning into the plan, you'll pay the trustee for the car rather than the finance company directly. And we will lower your payments. And it really does work. Just to be clear, as Jeff said, they can't repossess your car once you file bankruptcy. So don't be afraid about that. But we can change your payments or just give the car back and start over.
Right.
And get the fresh start you're looking for.
Exactly. Eric, if we file a bankruptcy for somebody, what happens with taxes? They might owe the IRS, the state of New Jersey taxes. They might have had a business and they owe sales and use tax to the state. What happens with those?
Jeff, with regards to income tax, okay, that's the one we see the most. The rules for New Jersey and the IRS are more or less the same. If you have filed all of the tax returns and there's no lien against you, and we can talk about this, if the tax is more than 3 years old, we can put it in the bankruptcy at Chapter 7 or Chapter 13, and it's treated just like a credit card debt, just like a medical bill, just like a payday loan. It goes away. Incredibly, income taxes, which are more than 3 years old, if they've been filed for at least 2 years, you can get rid of just like a medical bill or credit card. Now, if it's less than 3 years old and they have to be repaid, it's called a priority debt, a non-dischargeable priority debt. What's great about a Chapter 13 bankruptcy, this is very important to understand. It's great. It really does help so many of our clients. Number one, any penalty that you owe generally drops off the debt. It becomes a credit card debt. And number two, interest stops. When I said becomes a credit card debt, becomes a general unsecured debt, like a credit card debt. And interest stops as of the day you're filing. So you're given 3, 4, 5 years into Chapter 13 to repay income taxes. Interest is stopped and no further penalties. And it's a plan. It's your plan that we devise with you, right? With the going over your budget. The trustee accepts the plan payments that you can afford and get rid of tax debt over 3 to 5 years. It's really good. Now, Jeff, I'm out of water, so why don't you talk a little bit about sales and use tax? We do get a lot of clients who have that, okay?
Yep. And taxes are, Eric and I understand taxes very well, and they are a complicated area in bankruptcy, the interplay between the bankruptcy code and our tax laws. We understand exactly what to do with taxes, and we're giving you kind of a broad brush explanation of what goes on. There's a lot of little things that come into play, but we would look at all of that if you came in to see us. Now, if you owe sales and use tax, or you're an employer and didn't pay withholding taxes for your employees, we call these trust fund taxes because you were in effect given the money and you were going to act as like a trustee and then turn it over to the taxing authority, the state or the federal government. If you didn't do that, then you can't get rid of that tax debt in a bankruptcy. We can pay it. We might be able to get rid of penalties, which could be significant, but that kind of debt's going to have to be paid. But it can be paid in a Chapter 13, and the taxing authority just has to accept that. They can't do anything to you to try to collect the money.
Exactly. So you're still protected by the automatic stay, which we've talked about a lot today. So there's no collection actions, and it's Jeff and you or me and you and me can work on a plan to pay it back over 5 years. It's affordable. True, it has to be paid back, but it's your plan to pay it back rather than the IRS's plan to pay it back, which often isn't quite that friendly.
Eric, let's say something I know, just real fast about utilities, and then we'll talk about next week's program. If you're behind on utilities, and right now we have a moratorium in New Jersey on utility shutoffs, but just like with mortgage arrears, or if you're behind with your rent, there's going to come a day when the day of reckoning, when the creditor says to you, okay, the moratorium's over, we can shut off your utilities or whatever, unless you pay us all these back payments. If we file a bankruptcy for you and you owe utilities, and by utilities, let's say that we're talking about gas and electric for right now, limit it to that. We can erase those utility debts, and the utility company will actually give you a new account number, And so whatever service you have or use after the bankruptcy is filed, you'll have to pay for. But everything you owed them on the day the bankruptcy was filed is going to get erased. So utilities can, we can do good things for you if you're behind with utilities and we file a bankruptcy for you. Okay, that's all we're going to do today. Next week, we're going to talk about, I actually saw an article in the paper today, and Eric's going to, this is like a show and tell, why restaurants should file for bankruptcy. But we're going to talk about restaurants particularly because a lot of restaurants have been hit really hard by COVID, and the governors are threatening to shut them down again. And we're going to explain about bankruptcy alternatives for restaurant owners and all the things that you might owe, rent, taxes, utilities, whatever, and what could be done with them and how it could be done. There's a special kind of reorganization bankruptcy that was contained in the Small Business Act that we're going to talk about. It's kind of a hybrid between a Chapter 13 and a Chapter 11, which usually you think of a Chapter 11 as a business reorganization, and that's what it is. But for a small business, they created this special bankruptcy, and that'll be one of the things that we're talking about also.
Good.
So,
Jeff, I wish you, before we sign off, I wish good luck to your West Point Black Knights,
Thank you.
cadets,
Yep.
and go Army, boo Navy.
beat Navy. Yeah. Thank you. West Point 7-2, Navy's 3-6. Who's going to win?
Yeah.
We'll see.
See you next week.
Anyway, so we'll see you next week. Same time, same place, 2:00 Thursday afternoon. And until then, stay safe and God bless.